Good morning. Happy Monday. Hope you guys are all doing well and had a great weekend. Hope if any of you were in the path of those storms yesterday, which were quite crazy, that you were all safe and sound and didn't get damaged. If you're up in Michigan, whew, that's a wild day for your state. Yikes. You had tornadoes in one part and ice storm in another. They're saying if they met, and I looked at my husband, I was like, what's worse, an ice NATO or a sharknado? He said, I think shark. I was like, I don't know. What if it started throwing frozen sharks out of it? That's just my mind. We had about 20 minutes of storm, blew 2 trees down, no damage. It's out. We're good. Yo, Carmen, I feel like I just talked to you. Hello, Kelly. Hope you're doing well. Glad you were, I think, out of the storms. I think you said you were. Hello, Gabby. Hello, Taya. Good to see you. Thank you. That's one of my, I like this sweatshirt too. You want a Sharknado? I do not want a Sharknado. I also did not want those two weather events to meet because it felt like the Day After Tomorrow movie setting up for some stuff. But I do know there's a lot of damage out there, and I hope that everyone is safe and sound. I think we have another round coming in for us on Wednesday. Yay. Ew, don't say that. We do not have snow. No snow. Nope. And it's kind of strange for me with these thunderstorms this season because I don't have Hensley. So I don't have a constant panic dog, and I kind of don't know what to do with myself. Although my older Dane, he'll be 10 in June. He was a little panicky yesterday. I was like, no, no. Please don't start. Hey, Adair. Good morning. Hope you are safe and sound. I know your state got hit too. Alrighty. So we are going to, I know you didn't flash fan, and you are just fine. I'm happy to see you here, but take care of you. Take care of your family. This is, I know. Oh, you forgot to show me. I don't know that I need you to send it to me, Carmen. Hensley is, she was one of a kind. So you're in the tornado. It had Wi-Fi. Well, good for that tornado. Oh, dear. All right. So back on track. This week, Thursday, we will continue with day 2 of the Marcella Chittister trial that we started last Thursday up in Michigan. And we'll continue that Thursday evening. Not quite sure of the time yet. Thursday times might be a little up in the air for me just because it depends on when I get home from my dad's and what's happening here when I get home. But I'm going to try to probably start at around 5:30-ish. And I'm going to try to keep it there if I can. I will tell you, it's going to get interesting and you're going to get mad. Because I watched a little bit of it Friday with my son because I was showing him, and he wanted to see more of it, and I know he doesn't have time to watch my stream, so we watched parts of it, and you're gonna want to probably have a pillow or something. So today we're gonna continue with Aileen Wuornos. I skipped. I'm going to skip the witness that's outside the presence of the jury because it added nothing to it in this trial. Adair, 5:30, 4:30 your time on Thursdays because my Friday streaming is up in the air right at the moment and I couldn't stream. So I want to make sure that I at least get 3 streams in and a week, if I can stream on Fridays, I will. Sorry, Flash fan. I did watch ahead. But anyway, back to this one. So the last time we saw Aileen Wuornos was on the stand. The state was cross-examining her. The state said, "We have no more questions." Right? And if you remember, the state was asking her a lot of questions about the other crimes that she's not on trial for. She is on trial for the unaliving of Richard Mallory. Period, full stop. He's been lost in this trial since the beginning. Like, he was mentioned in the beginning a little bit, and then we have heard about these other crimes that she allegedly committed and confessed to. And he's kind of been lost. So the state says they have no more questions. The defense asks for a break. They come back. The defense does their defense thing, argues for a mistrial. Spoiler alert, didn't happen. And they had some valid points of, hey, we kept having to tell our client not to answer questions that the state was asking. There's no way that the jury, he said, wasn't tainted by that. There's no way. And I do agree with him. But yeah, we didn't watch the confession because it's 1992. It's on video. It's on VHS. We tried. Gabby and I messed around with it for a while when we just could not find a clean copy. We couldn't get this one to where you could hear it at all. It was horrible. So we didn't watch those confession tapes, but she confessed. She's claiming self-defense in Richard Mallory's case. The defense, and this is their fault for doing it the way they did an interview with Richard Mallory's girlfriend. Court TV has it as his mother. It is not his mother. If it was his mother, they had a weird relationship that would probably be illegal in most states. They did a 3.5-hour interview with her, detective, investigator, whatever he is, Herzepa, the one that we've seen a gazillion times with the mustache, and investigator or detective Munster, something. They didn't put her under oath during this process, and they didn't offer her, I think they did offer her counsel, but since they didn't swear her in, basically they were kind of like, you can't bring it in. So they brought her on the stand to ask her questions about what she had said in this interview, which had happened in January, I think, of 1989, maybe. It happened like 4 years prior to the trial. Well, a few weeks to them bringing her in, she apparently had a head injury. So now she's not remembering everything. So they're asking her questions about Richard Mallory on the stand, trying to bring in, remember I told you he was not necessarily a nice guy, trying to bring in the fact that he had been convicted of rape. So say it the friendly way that I have to, and served 10 years. The only thing that got out of this girlfriend was he told her that he was at a rehabilitation center. I was like, well, that's one way to put it, lady, but did you not read between the lines of what he meant by that? She said he was never abusive to her, but then also that she just, I can't remember. So there's just really nothing there. So we're not going to watch that. It's like an hour. And so then they bring investigator Herzepa back on and question him about, his synopsis of things that he wrote. And just, it was kind of just a really just starting to just be a circle of things we've heard 100 times from him because he's been on the stand a gazillion times. So we're just going to go 2 closing arguments, if that's okay with you guys. If you guys want to watch them, you can find them on the Court TV website. So if that's something you want to say. No, Dare, she did not confess before the trial ended. She always said Richard Mallory, her unaliving Richard Mallory was self-defense. She maintained that. She never said anything different than that, but her story around what happened kept changing. But she also talked about 6 other people that she unalived during 6 months to a year after Richard Mallory. So they brought all that in to help convict her in Richard Mallory's unaliving. This was the only one she was ever brought to trial for. She either pleaded no contest or guilty to the rest of them and was handed multiple, I think she ended up with 6 capital punishment sentences total, because one person was never found and they didn't, even though she confessed to it, they didn't charge her. So it's weird. Hey, Christine, how's it going? I hope you're doing well. I've been watching your channel. You're just growing like a weed over there. You're doing great. You are doing a great job. So we're going to go to closings. I started listening to these this morning because I was trying to decide what to do. I thought to myself, if Aileen Wuornos was not Aileen Wuornos that we know, who was kicked out, I think, at 14, who started hitchhiking around the country, according to her, at that time, from 14 to 16, I believe she said, working as a lady of the night. I'm still standing by gross for the men that took advantage of a 14-year-old child, whether she was offering it up or not, don't care. 14 that's gross. You had to know. If she was not this woman that we heard on the stand up there professing, yes, I had smecks for money. Yes, that's how I earned my living. I liked it. I had my limits. If the same thing happened to, I hate to use the word ordinary, but just a woman who had car troubles and some guy picked her up on the side of the road and they ended up in the same spot where Aileen Wuornos and Richard Mallory ended up, and the same thing ended up happening, would we take her story more seriously? Would we consider the fact that maybe it was self-defense? Would they have brought in, now he's gone, he's obviously unalived because he's the victim, but would they have tried harder to bring in his past to say he was a violent person, he had a criminal history, he served 10 years? Would they have tried harder to do that if she was just what people would consider quote unquote normal? And would we have listened more? But because of where she was, because of what she did, we didn't really pay attention. I don't know. It's just food for thought as you're listening to these closings. That's kind of just what I thought. And I just thought I would pose the question to all of you. So you let me know. Thank you, Adair. I have them. I got new ones. They're a little different and I'm struggling with them. So I can see everything pretty much. So I'm doing my best without them today because I'm still trying to get used to them. Hey, Daddy Short Nuts. prosecutor's tone showed disrespect for her due to her perceived position in life. I agree. And like I said, I'll start these and you guys listen to them however you want to. It was just throwing it out there for something to think about. If would you think it was different? Judge is bringing the jury in and going to explain to him what closing arguments are happening. And so just let me know how the sound is, please, and thank you.
Counsel for the defendant will have opening argument. Counsel for the state will have his opportunity for argument. And in conclusion, counsel for the defendant will have an opportunity to reply and rebuttal argument from counsel for the state. And the attorneys in making these arguments to you will be coming upon the testimony that you have heard and the evidence that has been admitted for your consideration. And they, as you, will be recalling the evidence in the case. Let me assure you they will not potentially try to mislead you. However, if your recollection of testimony differs from their memory, you must be guided by your own recollection of the testimony. Now, these final arguments, the attorneys, just as I instructed you on opening statements, are not to be considered by you as evidence of this cause. Our instruction of the law, the court will give you at the conclusion. Nevertheless, these arguments are intended to help you to understand the contentions of each side, and I would request that you give them your close attention. Mr. Miller?
Thank you.
One thing that was weird to me in this, the defense goes first and last. I don't know if it's because it's a capital case, but so that was odd to me. But just so in case you're wondering, I don't know.
Members of the jury, you are here today having heard and considered over 2 weeks of testimony in this case. Your job now is about to begin. You are to discover the truth. But you are to discover the truth, and by the truth, we mean what happened on December 1st of 1989. You are not to determine what happened in June of 1990, or in July of 1990, or in November of 1990. You are to decide but one issue in this case, for there is only one issue before you. That is whether Aileen Wuornos felt that she had to take Richard Mallory's life on December 1st of 1989. I remind you of this, people, because in this case, unlike any other, so much of what you've heard has nothing to do with the death of Mr. Mallory. So much of what you've heard has nothing to do with December of 1989. So much of what you've heard has nothing to do with what Aileen Wuornos was thinking when she pulled the trigger in December of 1989. In order to do your jobs properly, you have to remind yourselves that there will be other juries, there will be other judges who will make determinations as to what happened 6 months to 1 year after Richard Mallory was killed. You must consider Richard Mallory and nothing else. And you must consider that tragic evening when Aileen Wuornos felt compelled to take Mr. Mallory's life in a dark, secluded area in the early morning hours. And as you consider the facts and the evidence that came from that stand as it applied to Richard Mallory, and as it applied to what happened in December of 1989, 3 simple truths will emerge. Aileen Wuornos is not guilty of premeditated first-degree murder. She is not guilty of felony murder. She is not guilty of robbery. Consider the witnesses that the state presented to you. You did hear a lot of testimony, and early on you heard some testimony that Richard Mallory was found in an isolated area and that several items were found near his car. Remember that Aileen Wuornos told you these things as well. None of that is in dispute. You heard that among those items were a half-empty vodka bottle, 2 glass tumblers that were put in a little area near the car, Aileen Wuornos told you how they got there. And she told you how the bottle got half empty. You later learned that Smirnoff was Mr. Mallory's brand and that he had a habit of drinking a lot. And Ms. Wuornos told you this as well. You learned that Richard Mallory's pants were on when he was found, but that his belt was adjusted to one side approximately 4 to 6 inches, and that he had nothing on underneath his pants. And you will recall Aileen Wuornos told you how that happened as well. Later in the first week, you were told how Mr. Mallory died. You were told that he was shot dead. And you heard this originally from Dr. Botting, and you may recall Dr. Botting, who was kind of a heavy-set, white-haired gentleman who testified in the first week. Dr. Botting performed what he termed an autopsy on Mr. Mallory, but you might recall that Dr. Botting didn't draw a diagram to show you where Mr. Mallory had been injured. He didn't estimate the size of Mr. Mallory, and he didn't do any tests to determine whether or not Mr. Mallory had sexual activity before he was killed. Now, I call your attention to those things because you will recall you heard from other medical examiners and other experts who told you that those kind of things were standard procedures for a medical exam. And you should also recall, and perhaps more importantly recall, what Dr. Botting could not tell you. He could not tell you how far away Richard Mallory was when he was shot. He could not tell you the sequence of those shots. He could not tell you, most importantly, what was happening before Richard Mallory was shot. Simply put, Dr. Botting could tell you nothing about self-defense. He could tell you nothing to assist you in determining the only issue which exists in this case. So what other evidence did you get? Well, you learned how Mr. Mallory's car was found. You heard that it was found in an isolated area, and again, Lee Wuornos told you where this car was left. You learned that a search of local nude bars and strip joints was conducted to find Mr. Mallory. You also learned that a stripper named Chastity Marcus had been with Mr. Mallory shortly before his death, and that she was at one point arrested for the killing. You learned that Mr. Mallory was known to smoke pot, just as Lee Wuornos told you he had been doing in that fateful evening. Eventually, you were given some technical evidence. You were shown bullets. You were shown a gun. You were shown this gun. And you will also recall that Lee Wuornos not only told you that this was indeed her gun, and that yes, she had shot Richard Mallory with it, she told the police where to find it. As the trial moved on, you heard a great deal of testimony, and this is particularly true of last week, about incidents which began 6 months after Mr. Mallory was killed. You also heard the testimony of a certain Bobby Lee Copus. He was the rather heavy-set truck driver that came in, and he claimed to have met Lee Wuornos nearly a year after Mr. Mallory had been killed. When considering Bobby Lee Copus, first ask yourselves whether Lee Wuornos' behavior in November of 1990 had anything at all to do with what was going through her mind in December of 1989. Then ask yourselves, was Bobby Lee Copus telling you the truth? Bobby Lee Copus, who testified that he saw a gun in Ms. Wuornos' purse, and it was a small caliber firearm. And he knew it was a small caliber firearm because it was a tiny little gun, like the one his wife carried. I ask you to handle this weapon. Look at it carefully, and you determine. Was Bobby Lee Copus telling you the truth? A man who remembers verbatim what a complete stranger told him a year before, but forgot to tell the police about it? The answer is plain. Lee Wuornos was telling you the truth when she said she had never seen probably culpable. So after 2 weeks of testimony, 2 weeks of evidence, the state asked you to determine the issue in this case. Did Lee Wuornos act in self-defense? Well, they leave you with essentially 2 witnesses to decide this issue. Those 2 witnesses are Tyra Moore and Larry Perzecco. First, you will recall Tyra Moore. She was Lee's former lover. She testified in the first plea. Rather heavy-set woman, very short hair, and stoic in her appearance. And what the state wanted.
Apparently, if you're not as thin as him, you're heavy set. He has described everyone who was heavy set. Why does as heavy set? You'll remember him. He was heavy set. She was heavy set. They were heavy set. I am not. Like, come on. Guess you just wouldn't survive today, dude.
You to hear from Tyra Moore was that Lee Wuornos had come to her in December of 1989 and told her she'd killed him. And you didn't hear that from Tyra Moore. She said it over and over again. But what else did Tyra Moore tell you? And what were her motivations for doing so? First of all, recall that Tyra Moore was a suspect. She had wrecked a car and been seen in that car, and as a result, a picture of her appeared on the TV. You must remember that Tyra Moore had known for over a year that Lee Wuornos had shot Richard Mallory. And she didn't leave, and she didn't call the police. And you have to ask yourselves, what does that tell you? Either Lee was telling you the truth, Tyra Moore really did know that it was in self-defense. Or Tyra Moore just didn't care. But Tyra Moore did start to care, only when she saw that this might affect her, and not just Lee Wuornos. When she saw that she might catch some heat, she left. She went half a country away, leaving Lee Wuornos behind. And eventually Tyra Moore was found half a country away in the state of Pennsylvania. And eventually law enforcement officers talked to her about this case. And they asked her if she'd do them a little favor. She was brought down to the state of Florida. She was put up in a hotel room with money from our government. Meals were paid for, cigarettes were paid for. Her room was paid for, and all she had to do was write Lee a little note. Write Lee a little note and have Lee call her. And then Tyra Moore could fully implicate Lee Wuornos. And so Tyra pulled Lee's emotional strings during 11 phone calls in January 1991. And Lee Wuornos will do what Tyra Moore wants because Lee Wuornos loves Tyra Moore. Lee Wuornos would do anything for Tyra Moore. Lee Wuornos would die for Tyra Moore. And Tyra, of course, knew this, and she knew it well because Lee had opened herself up to Tyra and told her this on numerous occasions. So in January of 1991, Tyra Moore lied to her lover, and she cried to her lover, and ultimately she threatened suicide to her lover. Until Lee Wuornos, terrified that Ty would be arrested, or perhaps worse, gave Larry Perzecco and Bruce Munster and Ty Moore exactly what they wanted. And Ty went back up north. It wasn't long after Ty went up north that she got a friendly little phone call from Bruce Munster, Marion County Sheriff's Office. She was told at that time, well, she wanted to, she could share his lawyer. She could make a little money on this thing. How much money? You heard the figure $50,000, didn't you? And while it is true, Tyra told you she hasn't gotten any money for her story yet. Certainly she was considering it. She was considering it when she called her law enforcement friend Rose Jean Insani on the phone talk to her about it and ask her whether she should get over it. And consider that relationship, the relationship between Rose Giansani and Tyra Moore. Rose Giansani, a woman who was assigned to watch over a potential murder suspect for 4 days and gave her anything she wanted, paid for it with government money, and who's been in regular contact with this woman long after her job has required her to. You will recall Rose Giansani goes out to dinner with Ty. She chauffeurs her from the airport. And she brought her here to this courtroom, and she tried to sit in the courtroom while Ty testified. Nonetheless, Tyra Moore, as a witness, with her obvious reasons to try to please law enforcement and the state with her testimony, she did offer some valuable insights into this case. First of all, you will recall Ty told you that in 4.5 years of living every day with Aileen Wuornos, not once did Aileen raise a hand at her. Not once did she lay a hand on her. She said they already. More importantly, she told you not once did Lee strike anyone else. And you'll recall the question to the state attorney, well, wasn't there a time where there was a bar fight or something? No. And what did she tell you about Lee's drinking? Yes, Lee drank a lot. And she did drink to become more outgoing. And in fact, that's what happened when Lee drank. She did become more outgoing. That's the testimony of Tyra Moore. It is also the testimony of Lee Wuornos. Another thing that Tyra Moore told you, she kind of told you in a backwards way. You'll recall the state was asking Tyra Moore some questions. Well, when Lee came home in December of 1989 with Richard Mallory's Cadillac, was her speech all slurred? Was she stumbling around? No. But on cross-examination, one simple question. Was she intoxicated? Was she drunk? Yes. Again, Lee Wuornos told you this as well. And it wasn't long after Lee brought that Cadillac home that Lee tried to tell Ty about what had happened and how she had ended up with that car. And when Lee Wuornos went to Tyra Moore and told Tyra, I really need to tell you something. When Lee Wuornos confided in her only real friend in the world that she needed to talk to her, she needed to tell her something horrible had happened, Tyra's response was very simple. I don't want to hear about it. Just as Ty didn't want to hear about Lee's job because you'll recall Ty said she was jealous when Lee went out with other men. You'll also recall that Tyra wasn't so jealous that she wasn't willing to spend Lee's money. She just didn't want to hear where Lee got it. She didn't want to hear how Lee suffered to get it. She didn't want to hear how Lee was raped and beaten on numerous times. Tyra Moore didn't want to hear it. And the words, I don't want to hear it, should remind you of the other key state witness in this case, Detective Larry Horzepa. You'll recall that Mr. Horzepa took that witness stand on 3 separate occasions. And it was he who, with Detective Munster, talked to Lee for 3 hours a year ago. And it was that tape that you saw in this courtroom. Well, now you have the task of deciding Mr. Horzepa's credibility as a witness. And in doing so, consider this simple question. Why did Larry Horzepa have to take that witness stand and tell you what Lee Wuornos had told him when you could see it for yourself? The answer to that question is simple. Larry Horzepa put together what he called a synopsis of what happened to Mr. Mallory and what Lee had told him about it in January of 1991. And when he did this, he was very, very careful to extract anything which lets you know, number one, why Lee was talking to him in the first place, And number two, and far more importantly, why Lee shot Richard Mallory in 1989.
Hey, Tracy. I've been wondering about you. I wondered if you were feeling okay. So I am glad you're alive. And it is good to see you. I hope you're getting whatever health stuff is going on taken care of and that you feel better soon, that you're back in chat with us very, very soon. So whatever it is, feel better, or I hope you can get it fixed, whatever. But it is good to see you. I have been thinking about you. So thanks for letting us know you're alive.
Mary Horzepa did not want to know the answer to the only question which is important in this case. And that is, why did Lee Wuornos feel that she had to shoot Mr. Mallory? And it's just as obvious, should be just as obvious, as to why Larry Horzepa did not want you to know the answer to this question. The answer is simple. Because in spite of what he tried to tell you, the tape speaks for itself. And Lee Wuornos said over and over and over again in January of 1991 and again in January of 1992 that she defended herself in December of 1989. But Larry Horzepa, just like I, didn't want to hear about it. Fortunately, through the cross-examination that you heard in this case, Mr. Horzepa was exposed. Consider, if you will, his original testimony. You will recall that Mr. Horzepa had some notes right here on this stand. And you will recall that Mr. Nolas came and got these notes. And he looked at them. We had a few minutes over by the table. And when he was questioned again about those notes, you will recall that there was a reference in the typewritten notes which he had prepared to help him testify. In the typewritten notes, there was a reference where Lee Wuornos had said that this man was hurting her. And Larry Horzepa wrote in his own handwriting off to the side 2 words, which explained Larry Horzepa to each and every one of you. And those 2 words were, don't use. And don't use, people, means don't let the jury hear. Don't let you hear. You who are to decide what really happened in this case. According to Mr. Horzepa, you are to hear that Lee Wuornos wanted to talk and wanted to talk to investigators about Richard Mallory's death. But you're not to hear why. You are to hear that Lee Wuornos occasionally got confused in those 3 hours of statements. But you're not to hear why. You are to hear that Richard Mallory was shot by Ms. Wuornos, but you are not.
Holy crap, Tracy. That's kind of serious. Wow. Please take care of yourself. Yes, bed rest. Whatever they tell you to do, please do it. Wow. That's a lot. Very scary. Yes, just whatever the doctors say. Just do it. We'll be right here when they say you're all good to go. Yikes. I was not expecting that. But I am glad you're okay. You kind of shocked me there. I don't know what to say, but I'm just glad you are okay. And yes, please, please, please take care of yourself. Follow those doctor's orders, even when they suck.
Not to hear why. And why is the only issue in this case. You will remember Mr. Nolas asked Mr. Horzepa about this tendency of his on the stand. He asked Mr. Horzepa, why didn't you or Mr. Munster ever ask why Lee felt her life was in danger? Why didn't you ever ask what Mr. Mallory was doing to her? And Mr. Horzepa's response was, well, I wanted to let her talk. I didn't want to interrupt her. I didn't want to put words in her mouth. Well, remember these statements from the tape. At one point, Lee Wuornos saying, quote, he's hugging and kissing on me and all this, and then he starts, pushing me down, and I said, wait a minute, get cool, you don't have to get, and she's cut off by Bruce Munster, who interrupts her to say bye-bye to someone. But Lee continues, you don't have to get rough, And Horzepa's next response, does he ask what rough means? No, he says, well, where were you sitting in the car? Lee continued, he's getting really heavy with me. He's starting to get violent with me. We're fighting a little bit. Gary Horzepa, well, what kind of purse did you have? Later, Lee states that Mr. Mallory had not undressed and that she had said, why don't you take your clothes off? My God, it hurt to do that. Then he got pissed, calling me. He said, fuck you, baby, I'm gonna screw you right here and now. And Horzepa responds with yet another question about where are they seated in the car. Did he give Lee Wuornos an opportunity to talk? Or did he do everything he could to keep her from talking about the issue that matters most in this case? A final time, Lee Wuornos stated how Mr. Mallory kept coming at her, even after he'd been shot. And probably better than something that gives you better insight into Mr. Horzepa than anything else is you will recall his answer to that statement on the tape. He's coming out to get you. You already told me that. Whereupon he moves on to another issue. Is Larry Horzepa a man who wants you to hear everything? Or is he a man who in January 1991, and again in January of 1992, doesn't want anybody to hear what Richard Mallory was doing to Lee Wuornos? Is this a man who wants you to know the truth about what happened? Remember his testimony from the witness stand. Mr. Tanner asks, how long did she say she had the gun? Mr. Horzepa's response, 2 days. What was the real answer? You saw it. I don't know. Might have been a couple of months, only a couple of months before, I think. I might have got the gun just then. I can't remember, like 2 days before or something, because I can't remember. It's a long time. Was that an honest answer that Mr. Horzepa gave you? You decide. Question by Mr. Tanner. Did Lee ever explain to you a rape by Mr. Mallory? Answer by Mr. Horzepa. No. What was the real answer? Well, she did say he pushed her. She did say he hurt her. She said he kept coming at her. He physically abused her. He got rough with her. He got violent with her. And when she complained of being hurt, he shut her up and said, fuck you, I'm going to give it to you now. Is that a rape? Can the answer to that question be no? I submit to you, Mr. Horzepa cannot truthfully tell you she did not say she was being raped. He may truthfully tell you she didn't say that word. He didn't want to hear it. And Ty didn't want to hear it. You, however, have heard it. And you heard a nervous and confused Lee Wuornos tell you as best she could the rest of the story.
Adair, he knows this information because of the taped confessions that she made. Like I said, I wasn't able to play them because the audio on them is it's awful. I mean, it is awful. You can't understand what is being said. So he knows that's what was said. But that's what Horzepa, the investigator, testified to. And he did have notes that said that. And he did have writing on the side. He did have a synopsis of notes that the defense didn't have, and he did have written on the side of don't use. And like I said earlier, if just put a person that doesn't do the occupation that Aileen Wuornos did, for lack of a better term, just put a quote unquote ordinary woman in that, would they have treated her different? When she started saying all the things that Aileen was saying happened to her, would they treat her different? I'm going to say they would have, but I don't know.
A story which was so horrifying, it doesn't take a genius to see why she might not be willing to relate some of those details to a couple of unsympathetic detectives, officers who didn't want to hear it. Lee Wuornos told you she would do anything for Tyra. And when she met Larry Horzega and Bruce Munster at Tyra's urging, Lee Wuornos was clearly not concerned with herself. You can look at that tape and tell that. The state would have you believe that Ms. Wuornos somehow was trying to say that she had killed this man and that Tyra had nothing to do with it, but was lying to you on all the important stuff. Remember Lee Wuornos saying in that tape, "I deserve to die." What was her motivation for telling these officers that she'd been assaulted, she'd been attacked, she was defending herself? She wasn't caring about herself in January of 1991. She was caring about Tyra Moore.
I agree with you, Daddy Shortnuts. She has all those things. And she's hard to follow. I was incoherent. How many times did we hear that during her testimony? She didn't help herself at all. So I don't know. And we'll never know because that's not what happened.
Despite the efforts of Mr. Horzega, she was able to tell you as best she could on that day that she would be attacked. And later in this courtroom, Lee Wuornos may have been confused on that witness stand. She may have been rattled by the skillful cross-examination of Mr. Tanner. She told you the truth. And if at times she seemed angry at Mr. Tanner's relentless cross-examination, don't forget that Mr. Tanner is here before you, asking you to sentence her to death. It's not going to be long now before you're going to have to go into that jury room and make a very difficult and important decision. It will be difficult for you to do that and concentrate only on Richard Mallory, because you spent at least half your time in the last 2 weeks listening to things that had nothing to do with Richard Mallory. And as you consider those other things, those things which began in late May and early June 1990, 6 months after Mr. Mallory was killed, think about these facts. Richard Mallory was shot in late 1989. Lee Wuornos had been a prostitute for some 17 years prior to that date. And while she'd been raped and beaten before, it wasn't until a drunken stone, Richard Mallory, hurtedly, degradedly, and ultimately tortured Lee, that Lee took the action that she did. It was only as she lay naked in a strange car in a dark, secluded place after having undergone unbearable torture that she finally took a life to defend herself. You don't know, people, what such an experience did to Lee's mind, or whether she could ever be the same again. You do know, however, that she continued to be a prostitute. That's the only work that she knew. She continued to bring money to Tyler Moore, and she continued to go out on the road at least 3 times a week, several men on each of those days. And you know, therefore, that Lee Wuornos had sex with dozens of men in the next 6 months that followed. And you also know from the testimony that there were no incidents. And you also know that something happened again when she met David Spears in June of 1990. Maybe something snapped in Lee after that. Maybe she simply couldn't respond to anything normally again. Those difficult questions are not for you to decide. Those difficult questions are for other juries and other judges. Your job is much simpler, because the evidence in this case is much clearer. Far from being the predator Mr. Tanner described in his opening statement, Lee Wuornos was a victim. She was the victim of a brutal attack, a torturous attack at the hands of Richard Mallory in December of 1989. A violent attack which Mr. Ortega did his best to keep. Think about the evidence that you've heard in the last 2 weeks. You will realize that you've not heard a single word suggesting that Aileen Wuornos robbed anyone. You have not heard a single word suggesting that Aileen Wuornos committed felony murder. You have not heard a single word suggesting to you that she shot Mr. Mallory with premeditation. When you consider the evidence of Aileen Wuornos' intent in December of 1989, there's only one conclusion. For all of the evidence suggests she did nothing but defend herself. The evidence is all in. You've heard it. You've heard all of it. Follow that evidence to where it leads to one inescapable conclusion. You find Lee Wuornos guilty.
First, I want to thank you. It's been a long 2 weeks, and I know at times you.
This is the state, just FYI, because they went, it's weird to me. I don't know that I could have, even with what we saw, say that she did that with premeditation. Maybe I'm just wrong on that. But I don't know that that would be hard, because I don't know that she was just out hunting for people. But I don't know, maybe. You think that was weak? I have a feeling we're done hearing about Richard Mallory now, though, and the state will just be all the other ones. I do not think she's innocent. I do not think she's innocent. Flash fan. Flash fan. I love you. And no, this is not 1962 trial. Don't even go there. All right, here's the state.
Thought your time was wasted and wondered why it seemed to move in slow motion. I can assure you that all of us, particularly the judge, but certainly counsel from both sides, have been moving this case as rapidly as we could and can. I can also tell you that all of us, including the judge, have worked through the weekends on this case, and we've tried to minimize the waste of time. I don't think that jury service is any less important than service in the armed services. Certainly no less important than voting. And time you've given, time you will give, the part of yourselves that you will give as you deliberate and consider are something for us to be proud of as a nation, as a country, as a system. And it's one of the areas where perhaps our country does exceed in value of human dignity and value of right and value of protecting the accused and value of requiring the government to prove its case, not just say it. The value of all that we hold dear is typified and exemplified by what you've been and are now a part of. And I think from all of our hearts, we thank you for what you're doing. This is the only opportunity I'll have to talk to you until this case is totally over, and then only if you choose. And this is the only opportunity I have to argue. As you know, during jury selections, we didn't argue. During opening statement, we made a statement as to what we thought you could expect. And then finally get to the final stage of the case where the lawyers offer, I think, what we call argument. I'm not sure I like this part of the case or ever have. But they aren't going to change the system because of the way I feel about it. I would prefer an open exchange, kind of a forum. Let the jurors ask questions, let the lawyers answer as best they could, and judge your seat. But that's not the way we do it. So you're going to be stuck with me for about maybe 30 or 40 minutes, and I will try not to insult your intelligence, not to bore you with things.
It's because I don't have my glasses on, Daddy Short Nuts. I do not think she's innocent, but I am wondering why this poor juror over here, he has not been allowed. They've all sat in the same spots every time because that's the whole jury. He's never been allowed in the jury box. How come? You bet that guy is an alternate? He has this, yeah, but he's got the same, they all have yellow tags. I don't know. They never let him in the jury box. It doesn't look good. That's all I'm saying. Hey, that's actually pretty short, Adair. The closings in total are an hour and a half. We've seen people go on for days.
You already know very well. Try to point out what we believe the evidence has revealed in this case. First, let me tell you, you're going to receive jury instructions from the court, and lawyers on either side are not going to instruct you on the law. We will mention the law to you from time to time. The lawyer's argument is not evidence. In other words, what I say is not evidence. So what Mr. Knowles or part of that, Mr. Jenkins, Mr. Miller's team say is not evidence. The only evidence comes from the witness stand or from exhibits that have been offered. You should not decide this case on sympathy. Not sympathy for Ms. Mallory, and certainly not on sympathy for the accused. You're to decide on facts and on the evidence before you. Reasonable doubt. We discussed that a lot during jury selection. Listen to the judge's instructions. Reasonable doubt is not some mystical, hard to understand concept, but it certainly doesn't put a burden on the state to prove everything beyond any doubt, always. Matters that are subject to human beings cannot be proven beyond all doubt. There is no proof, virtually, of anything subject to human interaction that I would say is proof or provable beyond all doubt, especially when it comes to the matter of a crime unwitnessed by anyone except the two people, the victim and the attacker. Premeditation. Some of you may have had, it may still have in your mind, the idea that premeditation is long-range planning, conspiracy type things, the type of thing that would take days or weeks or even hours, perhaps at least. I'd ask you again, listen to the judge's instructions on premeditation. He will instruct you, in effect, that premeditation is simply carried out of act with an attempt, with an opportunity to reflect upon the action. It may only be the time between the picking up of a firearm and the firing it, or it may only be between the first and the second shot. surely by the third shot, certainly by the fourth shot. Determined intent to kill. You'll hear about felony murder. Murder is committed in the perpetration, in this case, of a robbery. You'll hear His Honor say that, if that's proven beyond a reasonable doubt, that's first-degree murder, Florida. They'll also talk to you about premeditated murder. If that's proven beyond a reasonable doubt, that also is first-degree murder. You will hear about justifiable and excusable homicide. And the way the instructions are framed and the way they are in every criminal case, you will hear Mr. Mallory's name. As if Mr. Mallory was doing this and she did that, that sort of thing. That doesn't mean the judge has determined anything with regard to the facts, except their version of the case would support an instruction of that nature. It doesn't mean that their version is true. It doesn't mean that the judge has accepted either side. He is as neutral, he is more neutral than anyone in this room. Anything that may have happened during the trial, we had all the numerous objections by both sides and the interaction between lawyers, that's really not part of the case. Sometimes a hard-fought battle over evidentiary matters, sometimes a hard-fought battle over legal theories, and the judge has to rule upon it. The evidence came from that witness stand, not what the lawyers are doing or not doing. It's what you base your verdict on. Not performance, not whether you do or don't like one side or the other. And none of us would want you to give that any weight at all. The verdict form. You will receive two. One deals with robbery. And I believe in its final form it has 6 options. It would be guilty of armed robbery, guilty of robbery of a deadly weapon but without a firearm, guilty of robbery without a firearm or deadly weapon, guilty of robbery without a weapon, or guilty of petty theft, or not guilty. We said, well, why do we get all these verdicts? It's a unique creation of the law. American, perhaps English jurisprudence as well, but that when a person is charged, let's say with murder in the first degree or robbery, they're also charged with everything within that charge. Perhaps the murder is a little easier to understand. The potential possible verdicts are guilty of murder in the first degree, premeditated, and felony murder as charged, or guilty of only first degree premeditated murder. Kind of cringe with the word only, certainly only in common parlance would be inappropriate, but under the law we're trying to distinguish. Guilty of first degree felony murder, guilty of second degree murder, guilty of second degree murder with a firearm, third degree murder with a firearm, manslaughter with a firearm, and not guilty. So when you see those, don't be confused. They will be kind of a line form, would be a place to check and a place for your four-person to sign. You only check one on each verdict form. I can tell you throughout our argument, and our position will be that you should check the one at the top. If it remains in the form it was when we added rough, and that is guilty of murder in the first degree, both premeditated and felony murder, and also guilty of robbery with a firearm. Aileen Wuornos has been portrayed as a victim by the defense. She's not a victim in any sense of the word. She's not a victim because she's a prostitute. She has chosen to be a prostitute. Her reasons, ultimately given, was when she first started out, apparently a pretty young woman, was that she only made about 75 cents an hour working, but she could make $60 to $100 at a time for sex. And she learned very quickly that was, for her, a preferred way to make a living. And that preference, that choice is carried on throughout her lifetime. This is not a victim prostitute. This is not a child wandering the streets with no choice. This is a grown woman, a healthy grown woman, with the capability of making an honest living if she wants to. She has chosen not to. She is not a victim. She indicated she liked sex. There's nothing wrong with that. But that's one of the reasons she was out there. She tried to push it off on the men, something to the effect that, well, they would keep their pants on and keep their wallets in their pockets. we wouldn't be out here. I guess drug dealers could say the same thing. People wouldn't buy drugs, they wouldn't be dealing drugs. Therefore, we should excuse them. It's really not their fault. They're victims because they want to buy their product.
Objection, Your Honor.
Just a,
Request the period of instruction, Your Honor.
your disregard, that's coming in.
In that vein, let's go back to where we both started. In the defense case, you were told by Ms. Jenkins, essentially that night, Aileen Wuornos was hitchhiking, but she was afraid and hiding. Now, what was she afraid of? This is what she did for a living. This is where she chose to work. She chose to work in highways, and she wanted people to pick her up. Where is this aura of fear that she's hiding under the underpass and doesn't know what to do because she's on the highway stranded? And an automobile stopped and it frightened her. Well, I don't know that you have to be a prostitute hitchhiking. Any hitchhiker usually is delighted when they see the car stop. And I submit she was delighted when she saw the car stop. It was heading the direction she wanted to go. And she found it had a lone white male in it. That is who she preferred to ride with. She got in and she headed to Daytona. Ms. Jenkins said that this woman had been beaten and raped repeatedly. And yet, Tyra Moore said not once in 4.5 years they lived together did she ever come home and say she'd been beaten or raped. Ever. It just didn't happen. That she had, in the distant past, been beat up pretty good apparently one time, if she's telling the truth. But in the past 4.5 years, there's not been any physical assaults upon her, any beatings or rapings. None reported to anyone. Certainly not to her best friend. And if you're going to report that to anyone, you report that surely to no one else, to your best friend. She said that, Ms. Jenkins said that time and time again, Aileen Wuornos was not paid. Well, that may have been true. Maybe sometimes she wasn't paid. And she said that Mallory told her to disrobe, and he wanted her to take her clothes off, but we've learned even from her own testimony that it was her policy to take the clothes off. And then they went on to say that after the alleged assault, that she went home and told Ty Moore basically the facts of being raped, sexually assaulted, and the various other very unpleasant things that she heard in the courtroom. But Ty said, well, I don't want to hear any more. But Ty was very supportive. Well, that's not supported by anything at all in this courtroom in the way of evidence except the statement of Aileen Wuornos. Everyone else's testimony is absolute to the contrary. She said, back to Ms. Jenkins in her opening statement, that Aileen Wuornos was really drunk royal, I think. But we heard Aileen Wuornos on the stand say that she had one mixed drink, and then Miss Mallory bought her a 6-pack of beer. And as over the next 5 hours, she drank it. She never even said she completed drinking the 6-pack of beer. Apparently, she had at least one left, if not more, because she had one to drink after she killed him. Sat on the car and drank the beer. That is not a person royally drunk out of their minds. Going to Mr. Miller's statement a few moments ago before lunch, and I want to address that directly before I move into some things I would like to point out to you. He began telling you that this was unlike any other case. Well, every case is different, but it's not unusual to have similar fact evidence in a case where there's evidence of other matters that are relevant material brought up in the trial for the substantive offense.
Objection, Your Honor.
Rule.
And so there's nothing extraordinarily unique about what's happened here in this courtroom. I think probably the most unique thing is the woman in this circumstance. That's probably the most unique to the whole case. Because this woman said about a pattern of behavior that is unique. You were told by Ms. Miller that other juries in other cases would render verdicts on the other killings, and that's entirely true. You are not here to find her guilty or innocent with regard to the other killings. The only verdict that you're going to be asked to render would be that regarding Mr. Mallory. But at the same time, it doesn't mean you should not fully face your responsibility. I implore you, and I don't think that you would, but don't even think, well, someone else will do it. This is your duty today. I trust you will face that with the courage and the determination that it's going to require. You were also told, regrettably, I think, as far as I was concerned by Mr. Miller, that your decision had something to do with whether she lived or died, and that whether you sentenced her to death by your verdict. That is not where we are in the case at all. This case is divided into two portions, bifurcated. Legally, we have chosen in court to separate guilt or innocence and the evidence concerning that. And if a verdict with first-degree murder is reached, then what penalty? But under no circumstances does the jury sentence anyone.
Objection, Your Honor.
Overruled.
Judge is the only one that sentences people in this courtroom.
Objection, Your Honor. Please reserve argument. Evaluation, Judge.
Be reserved.
Your Honor, I thought we had an agreement that there would not be objections. They were all reserved and that he would interrupt not during the trial. But my closing, we didn't interrupt them.
We did have an agreement, Your Honor.
We sure did.
I've been touching on what I thought to be the most serious. And Mr. Tanner, apologize for interrupting the floor. You simply wanted to reserve argument.
May proceed.
So penalty should not even be in your vocabulary, let alone in your mind, time to decide guilt or innocence, as far as we are at this point. Then Mr. Miller said that all these other cases had absolutely nothing to do with the murder of Richard Mallory. That's incredible. That's incredible. The law, and the facts, and the circumstances of this case. Similar fact evidence that is evidence of other crimes is relevant and material and properly and legally should be considered when ruled admissible by the court in criminal cases and even in civil cases. The case involving Mr. Mallory is a case on trial. This is the only case in which you are to determine guilt or innocence. But with regard to the second victim, Mr. Spears, third, Mr. Carskadden, fourth, Peter Sims, fifth, Troy Burris, Dick Humphreys, last, Walter and Antonio and their automobiles, and the locations of where the bodies were found and where the cars were found, is all relevant and material key issues in this case. Key issues and instruction was read to you. I know it was a while ago. You'll hear, I think, the same or substantially the same instruction again before you go to the jury room. Basically indicates that similar fact evidence, that evidence of other crimes, when it's relevant to prove identity, opportunity, preparation, plan, common scheme or plan, pattern of criminality, intent or motive. In this case, we submit the absence of self-defense is relevant. It's relevant. It's relevant to what she did to Mr. Mallory. John, may I move this one a little closer? Can you see on that line? Richard Mallory was killed in December 1st, precisely. 11 miles from the downtown Daytona Beach area. He was 51 years old. David Spears, killed in June, 112 miles. Charles Carskadden, June, 94 miles from Daytona. Peter Sims, reported missing in June. The body never recovered. This is the one she said she left in Georgia. Troy Burris, the sausage man, the way she identified him and by his vehicle, August the 4th, 1990, 64 miles from Daytona. Mr. Humphreys, who's the HRS man, September 1990, 68 miles. Walter Antonio, November, 147 miles. What do these men have in common? All of them were white males between the ages of 39, 60 years old. They're all traveling major thoroughfares in Florida. They're all traveling alone. Each of them made one fatal mistake. They picked up Aileen Wuornos. In each of those cases, she propositioned them for sex. And she ultimately killed them all in isolated areas where there would be no witnesses. She shot every one of them in the torso. A couple she also shot in the head. Multiple gunshot wounds, all from a .22 caliber hollow point. You heard the bullets described over and over again. Virtually the same bullets. Same pistol. This has been by her. Every one of them's property was stolen. Their vehicle was taken. And the vehicle was wiped clean in the case of Mr. Mallory, Mr. Spears. Mr. Carskadden's vehicle was stripped. It was on the side of the highway before police were able to do much with it. Peter Sims, that was the one that turned over on 4th of July, and both of the women were in that case, in that car. Both the women were riding around in that car. I say both women, Tyra Moore and Ms. Wuornos. And that's the vehicle in which her Aileen Wuornos' bloody handprint was found. The other three vehicles were all wiped clean again. The license plate was removed on 5 of the 7 vehicles. All the vehicles were left abandoned, and they were left abandoned in a range of from 12 to 170 miles. Finally, the property of 3 of the 5 men was found in her mini warehouse. This evidence demonstrates a pattern and a method of criminality, an intent and plan to carry out robberies and murders on the highways of the state of Florida by this woman. And she had picked a selected target type individual to kill.
Your Honor, if we may reserve argument from this.
In our opening, I told you that on November the 30th, 1989, when 51-year-old Richard Mallory turned east onto I-4, he didn't know that he was living the last 10 hours of his life. He didn't know that in less than 10 hours he'd be robbed and left to rot in the woods. Of course, he didn't know he was about to pick up this woman. Nor did he know that for whatever reason, she had begun to change her course of conduct, as far as we know, to a lethal and deadly pattern that would be reenacted over the next year 7 times. Her appetite to control men And that's what most prostitutes are about. Besides money, it's control.
Objection,
That's
Your Honor.
tremendous control. Take all the man has.
Your Honor, objection to.
I'm writing it down, sir.
Thank you, sir.
Look for it with the stipulation of the party.
To take all the man has, physically. Some say spiritually. It's tremendous and almost absolute control. There's only one thing left. Only one thing left. And that's to kill. You can't have much more than all the person, except their life. And that's what she wanted. And that's what she took. The evidence. Let's look at Dr. Bodding's evidence. And let's look at what his testimony showed us. Would a chart or drawing of Mr. Mallory's body told you any more than this shirt? This is the shirt he was wearing when she killed him.
I don't think that was the point. I think it was the point of it's standard and he didn't do it and it was weird. I thought it was weird when he said it. He didn't have it. They all have diagrams and they all know all the weight and height and everything else that guy didn't know. So that's kind of, ugh. I've not been impressed with either closing so far. But I didn't hear a little bit of his because I got a phone call. So I don't know.
As best we can reconstruct from the shirt, the dead man, and her testimony, her various stories, is that he was sitting in the car behind the wheel. There's no question about that. We also know that a bullet, perhaps the first bullet, and that coincides with her testimony, by the way, and her stories, entered in the rear of the shirt, rear right arm up in the shoulder, went through the armpit and on into the chest. That's not indicative of a man on his knees over the top of an attacking woman. That's indicative of a man even with his hands on the wheel. And we will never know. We will never know all we have occurred and the evidence. For a man shining back, but we don't have a man on his knees over a victim. It's not there. Yeah. This proves that. The tragic bullets. No way for us to know what order. We can only go from what she said, plus the evidence of the autopsy here, plus her common sense. But if he did, in fact, say, oh, when he was shot, if she said, and she said she thought she shot him in the side from outside the automobile, then that was probably the first shot. And then perhaps a second shot in the vehicle up in and through the neck. From the neck up was so decomposed, there was no track of a bullet discernible. But there was a definite track of a bullet from within, and it was horizontal, across the body, not up and back. And then there are the other two shots, we believe delivered after she ran around in front of the car she described. One of them at a slight from the right angle and traversing, and arguably that could have been delivered from the other side of the car as well. As she moved around, he was in there trying to get further away from her. We know, according to what she told the detectives, that he tried to get away and tried to get out the door and shut it. He crawled out of the car. Those were her words. He crawled out of the car. And then she ran around in front of the car and came around, and she said that she says he got up, she shot him again, he fell down, she shot him again. In here, she tells a little different. I don't know that there's any comfort for her. She says, I went around the door and opened it. And why do you think she went around the door and opened it if that's what she did? If what she told the police wasn't true, but what she told you was true? Why did she go around there and open the door? She hadn't finished killing him. That's the only reason in the world. For her to go in there and close with this man again, open the door and shoot him. That's her best story. That's the best story she has. The story she told the detective was he went down, she shot him again after he went down. And you know, that's confirmed, perhaps, certainly supported as a viable action, because the bullet, according to Dr. Body, went straight in. Straight in, and the others had an angle. It's the only one that went straight in, indicative of a shot delivered straight down. If you prefer to accept her version, she opened the door, and he's looking at her, and she shot him there. Either one is first degree murder. You don't have to debate on whether she shot him lying down or if she shot him sitting up. The point is, she was going over there to kill him. And that's what she did. That's exactly what she did. It's what she meant to do. It's what she intended to do. And when asked why did you kill him? Right near the end of her testimony, she said, why did you kill him? She said, the police would never believe me. I'm a prostitute. That's the best story she has today. And so, inferences, therefore, I had no choice but to go ahead and snuff him out. Witness elimination. Witness elimination. Even if the whole story were true, I submit to you it was not. But the last story she told, even if that whole thing is true, she has absolutely no right to go over and snuff out his life because she's afraid someone might not believe her. She determined to kill him. For whatever reason, and she told us. Why would Ty Moore come in here, as Ms. Wuornos said, and lie? They were very close. They were good friends. They were lovers, close as peas in a pod, close as a knot. Heard all those descriptions by Ms. Wuornos and not denied by Ty Moore. Ms. Wuornos says because she knew it was self-defense and she might be in trouble if she told it was self-defense. Now, how would that cause trouble? If anything, it might give some moral justification to the fact that Ty Moore didn't come forward and tell about this killing. That she believed her girlfriend was raped and brutalized, and therefore, because of horrible things done to her, she didn't tell anybody. Because the guy deserved to die anyway, and we're just not going to tell anybody. We killed a rapist. She killed a rapist, and we know about it. That would have been the most logical story if, in fact, it was true. But it wasn't true. It was not true, because it is not true, because she never told Ty Moore that. What she told Ty Moore, and told her several times just before the news came on, as she was drinking, she was one of those. And she knew that this car she'd been driving around in that day was suddenly going to be on television because there was now a body. You know, simply an abandoned car doesn't make the news. An abandoned car linked to an abandoned rotting body makes the news 2 weeks later. 2 weeks later, she realized, uh-oh, Ty knows I have this car. Ty really didn't borrow this guy's car. I found a body in the woods, where she started off. Found a body in the woods. And then Ty said, what are you talking about? And she used some profanity, got loose talk they use among themselves. And finally she said, well, I had to kill this guy. What? You're blaming me? Come on, you're kidding. I had to kill this guy. And that's it. Or I killed this guy. She used the word, I had to kill this guy. I killed this guy. And that was it. That was the whole story. This is her best friend, roommates, sweethearts, companions. Doesn't tell her anything. That is incredulous. You don't need a expert, the way of a pathologist, who want to tell you what common sense tells you. In fact, if it was for the story, now the other reason Ms. Wuornos gives us is, well, it was a story. She wanted a story. She's going to make, gosh, I don't know, it sound like $5 million or $500,000. Either one's a lot of money. She's going to make a lot of money by lying about this self-defense thing. Well, that's just not true, is it? Wouldn't it be a much more interesting story and a much more sellable story if this poor, pitiful prostitute simply doing her job, and some guy did some horrible things to her, and she killed him in self-defense? Now, that's a good story. Got one that's even better. And then her girlfriend, who knew all about it, got on the stand and told the jury how it was self-defense and how when Aileen came in, she had bruises on her neck and could hardly talk because the rope had almost choked her, and had been beaten brutally, and that she ministered to her private parts of her body because they were torn, and there was blood in her clothes and her underwear, and that this was a terrible thing. And then, despite the fact that this poor woman was raped and brutalized by this animal, the state of Florida tried to convict her. And a good, reasonable jury saved her. That's a good story. That would sell a lot of books and movies. And would be a gross injustice. The attack upon Deputy Horzepa, who is not responsible for what items are or not presented in evidence. The prosecution is responsible, along with the defense ruled upon by the court, as to what you receive in evidence. Deputy Horzepa has done nothing except sit here and testify under oath like any other witness and tell you what he did and what he had. She says she was cut off continuously, couldn't finish her statement. Her lawyer was sitting there. Would any lawyer, allow the police to cut off his client so she couldn't tell her story if she had a story to tell? In 3 hours and some odd minutes, you only have about 25 minutes of it, though. Is there one shred of evidence or testimony by her where she says that she was tied up, even tied up? How about just stopping there? I thought the story was going to be a coat hanger tied her up. I thought they were going to say that she was tied up with a coat hanger. Remember all the big issue about was there a coat hanger, was there a straight coat hanger? And I didn't know, and we don't know where they're going. We just have to wait and hear it when it hits the stand, same as you. So we spent, I guess, half hour on coat hanger. That didn't mean anything. In fact, we also didn't find any electrical wire, didn't find any rope. Abandoned in either place. Found the evidences of some drinking, perhaps some partying. She was told to tell it all. She was told you have an opportunity to tell everything. She did tell us something. She said what she deserved. But she never told anything about a rape. She mentioned the word rape a couple of times. Spread out over 7 stories of men. She never said that Mr. Mallory raped her. Certainly never said that he tied her to a steering wheel. In fact, if you recall, I asked her about this anal rape thing, and she said, no, that's a different one. That's a different man. Different one. Doesn't count. Can't talk about it. In fact, she's told you that virtually everyone in the courtroom is lying. Even Bobby Copus. Remember Mr. Copus? Looked like a trucker. I guess truckers are pretty big guys. I'm sure there's some skinny truckers out there, but most truckers look big, at least in the movies and on this witness stand in this case.
Hey, Sharon, how are you? It has been a while since we've seen you. Everyone has been sick, and I understand about Crohn's. I hope yours is, hope you're getting it under control. Because it sucks when it's not. I know that from experience. And thank you on my hair. But I hope you're getting everything better and getting things back under control, and we'll be back with us soon. So take care of yourself so that you are back in chat, because it's been a while. You've been missing.
Even Mr. Copas, she says, is a liar. And I don't like to use that word, but that's what she said. Because he wants publicity. Well, did Richard Mallory give her money in advance? And then was she afraid he wanted to take it back, as she said in her first statement? Or was he just a nice guy and she decided she could trust him and wasn't worried about the money until they got to argue about unzipping his pants, as she said in the second story? Had she had the gun 2 months or 2 days? Well, she corrected herself. She's the one that narrowed it down to 2 days. She said, oh, wait a minute, went back to that herself. It was no prompting from anyone else. That's why we accepted that as the best version. Pretty good evidence. Because it was only a couple days after she said she got the gun the killings began. Something about having a gun that changes some people. And maybe it's a good thing we don't let convicted felons have guns, despite her view to the contrary. She was pretty astute on the stand, and certainly 2 hours on the stand or so would not be easy for anyone. But she was able to correct me on what pages in the transcript certain matters were. Oh no, that's on page 9. You better look over on page 53. I said, well, we haven't got there yet. We'll get there in a few minutes. Asked her about the trajectory of the bullet. Remember Dr. Body talked about the trajectory of the bullet? She said, oh, I thought the body was too decomposed for anybody to tell the trajectory of the bullet. She wasn't missing a lick. She knows what she's doing. And she has carried her pattern of manipulation into the courtroom to try to manipulate your verdict. She told you that she was threatened with the arrest and persecution and prosecution of Ty Moore. That's the only reason she said all these things. I think that's a clear choice there. Either Deputy Morzeppa is flat, sitting here not telling you the truth, or she's not. There's no gray area there. Someone of the two is not telling you the truth. In fact, she told us in her testimony, she said, I'm the only one telling the truth. Everybody else is lying. I think she said, except me and my lawyers. But everyone else is lying. To convict an innocent person, she told Ty Moore just enough that Ty wouldn't flip out when she saw the car on the television she'd been riding around in 2 weeks earlier. She didn't tell her anything else. Ty Moore should have come to the police. Ty Moore should have reported it. And maybe, just maybe, it would stop right here. Ty Moore is going to have to live with that. Ty Moore is not on trial. This is a murder trial for Aileen Wuornos. That's where it should have ended. This is because people don't want to get involved. And goodness knows, you've seen some witnesses here, you see why they don't want to get involved. But we've got to be involved. You've got to be involved. the system isn't going to work if we hide behind our privacy and our fears and our private lives. Time Lord, refusal to either believe or accept and believe, and then to tell anyone could have saved 6 men's lives. And that doesn't hold her up for anything respectful or honorable at all. By the same token, if she'd been told this was a brutal anal rape, etc., it would have at least given her some moral justification for not saying anything. And she knows that. And she would have said that if it's true. Because it's not true, she didn't say it. It was bad enough that she didn't come forward. At least she didn't sit on that witness stand and lie to you to perpetuate and protect this woman who killed Mr. Mountain. We heard a lot from her. This is a murder out of greed. This is a woman who can make, according to her own testimony, I don't care how you figure it, $30,000 to $50,000 a year and squander it just as quickly. This is a woman moving out of power and control into a new and unfathomable for you and I area of domination to the extent of snuffing out life. It became obscenely simple to have it all. Is there any answer to the whys and how did this happen? Not for this jury, not for this time, and not for us. She chose her life. She chose the time and the place. And she has left you no reasonable choice. No reasonable choice under the evidence of this case, except to find her guilty of murder in the first degree and armed robbery. Thank you very much. Thank you, Mark.
Forgive me if I'm a little disjointed in my final remarks to you, members of the jury. I have a lot of things to respond to based on what you just heard. I would start out by agreeing with Mr. Tanner about one thing, and that is that your service is vital. In this case, it is an exceedingly important job. Take it seriously and think about everything that you have heard. And when you're doing that, demand of Mr. Tanner proof, not speculation. Demand of Mr. Tanner evidence. Mr. Tanner just talked about, well, maybe he was like this, or maybe he was lying down. Maybe a straight shot means he was lying down. Well, maybe a straight shot means that this man was coming right at this woman. And maybe a straight shot means he was right on top of her. How did the shot hit in the arm? Think about it. Some man's coming into a car to get a woman. Maybe that's how it happened. But maybes don't cut it in a court of law. Maybes don't work. Perhaps doesn't work. The burden is on the state, and the state has given you nothing. Demand more. Mr. Tanner speculates, well, Ty would have been on high moral ground if she'd have come in here and said something about being told that Lee was anally raped by Mr. Mallory. What better reason for Ty Moore not to go to the police when she was first told about it? Lee Wuornos told you that she told Ty Moore why this thing had happened, and there's no better evidence than what Mr. Tanner pointed out to you. Mr. Tanner spoke some about the robbery charge in this case. But you listen carefully to the robbery instruction. And you listen to whether or not there was any evidence that Lee Wuornos threatened anybody or killed anybody or did anything to get property. Is Lee Wuornos guilty of theft? Sure. Find her guilty of theft. She should not have taken that property. I suggest to you, you don't have to find her guilty of theft, that her actions and her state of mind were such that that can be excused. But there's no legal justification for finding her guilty of robbery. I also agree with Mr. Tanner about another thing, and that is that we don't want you to rely on sympathy. I'm not asking you to feel sorry for Lee Wuornos. She doesn't need your sympathy. She needs fairness. She needs justice. She needs you to understand what really happened in December of 1989, and she needs you to return a fair verdict. She needs you to interpret exactly what the evidence that came from that stand has told you. And that is that she had every right to shoot Mr. Mallory. She had every right to shoot him not once, not twice, not 3, but 4 times. She was terrified, she was drunk, she was naked, she was tortured, and she defended herself. That's not a crime. Don't ask you for sympathy. The law says she's not guilty. Mr. Tanner also got up here and he spoke to you about the fact that Aileen Wuornos is a prostitute. Aileen Wuornos asked to be a prostitute. Well, did Aileen Wuornos ask to be slapped? Did she ask to be tied to a steering wheel? Did she ask to be anally assaulted? Each and every one of you in jury selection indicated that you could be fair. Each and every one of you indicated that a prostitute, yes, a prostitute can be raped. Mr. Tanner suggests to you that somehow she brought this all on herself because of her profession. She was raped and she was brutalized. And despite her profession, she had a right to defend herself. Mr. Tanner quarrels with Ms. Jenkins' opening statement. He says, well, what was she hiding from? Well, I believe if you listened carefully, the opening statement was that Ms. Wuornos was underneath the culvert because it was raining and it was dark. And when this car backed up, that in fact she was worried about who might be inside. And that's exactly what she told you from the witness stand. Then Mr. Tanner went on to say, well, Lee told you that she had told Ty what had happened back in December of 1989, and that she had told Ty that it was self-defense, but everyone else said something different. Where's the everyone else? You got Tyra Moore, and you got Lee Wuornos. What do you mean everyone else? And what are Ty's motivations? Mr. Tanner asks you, why would Ty lie? Don't forget who her friends are in this case. Mr. Tanner suggests, well, self-defense would make a whole lot better book, a whole lot better movie. Yeah, except the person who told her about the $50,000 and the book and movie deals was a law enforcement officer. Her best buddies, Rose G. and Sonny, of the Florida Department of Law Enforcement. What are her motivations to come in here and say something to convict Lee Wuornos? You be the judge. Mr. Tanner talks a lot about prostitutes and control and taking the man for everything he has. Have you heard one single shred of evidence that talks to you about what prostitutes think? Have you heard an expert come in here and say they can read prostitutes' mind? What did Lee tell you about prostitution? About the numerous times she was beaten, about the fact that her lover didn't even want to hear about it. Her lover who was more than willing to take her money. but didn't want to hear about it. Mr. Tanner quotes Lee and says, well, I told her that I killed this man, speaking of what she had said to Ty, and Ty's response was, you're blanking me, I don't believe this. That's what Lee said in 1991. And why did she say that? It's obvious. The whole reason she was there was to clear Ty. What's she gonna say? I told her all about it, she believed me, but she didn't do anything. And Lee told you that from the stand, that's why she made those comments as well. She told you that. The fact of the matter is, Ty Moore told you that her response to Lee was not, you're blanking me. Ty Moore told you 2 weeks ago, my response was, I didn't want to hear about it. And that's what really happened. When you look at the evidence in this case, look carefully at this photograph. Mr. Mallory's vehicle. You heard Lee Wuornos talk about a rape. You heard how she said she was tied to the steering wheel. You look at the steering wheel, get a chance. Look at it carefully. Look at the condition of the steering wheel and ask yourselves, is that consistent with what Lee told me from that stand? It is. It is. Then Mr. Tanner said something that was almost humorous. He said,
Sir Frank, is there such a thing as an expert lady of the night? It's that would be that'd be quite a weird thing to expert in. But Aileen, she had 17 years experience, so would that not qualify her as an expert? Her CV, she could write it. Be lots and lots of pages long.
Said, well, if Lee was getting cut off, she had her lawyer there. How come her lawyer didn't do anything? Watch the tape. Listen to that lawyer. First of all, it's enormously difficult to understand a word he says because his accent is so thick. Second of all, she'd never met the man before in his life. Third of all, he didn't say a word other than making a blanket statement to cover himself that, well, I kind of talked to her about the fact that she doesn't have to testify. And more importantly, he left in the middle of the interview. Mr. Tanner spent a lot of time talking about Mr. Body, and then he speculated as to what the sequence must have been based on all these things and principles. What did Dr. Body tell you? This is his expert. This is what he put on the stand to teach you what happened. He said, I don't know what sequence. I don't know where they were positioned. I can't say what they were doing. And again, he certainly said, I can't tell what was happening before the shots were fired. The state has given you nothing to show anything except self-defense in this case. Nothing. Mr. Tanner, in essence, is arguing to you that you have to convict Lee Wuornos. You have to convict her based on what she did not say at certain times. The fact of the matter is, you must acquit Lee Wuornos because of what she did say, both in January 1991 and here in this courtroom. when you consider the Mr. Spears, and Mr. Carskadden, and the other things that Mr. Tanner talked to you about, he suggested that I somehow argued that it wasn't admissible. Of course, those items are admissible. You saw them. If they weren't admissible, they wouldn't be here. What I suggest to you is they are meaningless in this case. And they are for other jurors. And they are for other judges. Because what Mr. Tanner did not explain to you when he went through the dates on these things is that, yes, Richard Mallory was killed in December of 1989. David Spears died in June of 1990, 6 months later. The things that happened after Lee Wuornos went through the hell that she went through in December of 1989 are not indicative of what she was thinking at that time. It's not logical to assume that her behavior 6 months later had anything to do with whether or not she was being savagely raped. If anything, her rape explains any future behavior. You didn't hear anything about anyone in November of 1989, or October of 1989, or September of 1989, or September of 1988, or 87, or 85, or 75. No, it wasn't until Richard Mallory did what he did that Lee Wuornos responded. The evidence is clear that she had every right to do that. You're about to go into that room, you're going to be instructed on the law first. And when you go back there, demand proof from the state, not speculation. Consider what you've heard from that witness stand. Consider Larry Horzeva and Tyra Moore for what they are. And consider whether or not Bobby Lee Kopis is telling you the truth. And consider how many times Lee Wuornos cried out. She responded in self-defense in this case. And when you do that, and you assimilate all that you've heard over the last 2 weeks, there's only one verdict you can return. And that verdict is not guilty to each and every count.
Unless you guys are just on the edge of your seat to hear jury instructions, we're going to skip. Taya, I wouldn't say you missed anything. I thought the state was kind of rambly, and I'm with Flashman. I couldn't acquit her. I mean, yeah, you can. If you took the other people out of it, I think they may have had they might have had a harder time. I still, like I said, you put a normal, I'm using that term because I don't know another one to use at the moment. Take a ordinary person and put them in that same situation, I think they might have listened differently. But boy, does this attorney like to describe people and not in nice ways. I mean, we got heavyset. We've got, you can't understand him because of his accent. I mean, I have a feeling that somebody had to have some more CLEs after this. Like, okay. Yes. Yes, Daddy Shortman. That's the executive summary. There are a lot of heavy-set people in Florida. You'd think it would be the opposite because they got the beach and stuff. Must be middle Florida. I don't know. But anyway, we're going to the verdict. I know there's no spoiler alerts, but I guess spoiler alert, if you if you don't know, you don't know. You're about to find out. I did not have time to look up to see how long they deliberated. Oh, and there's closed captions on these. Flashman. I don't think so, sir. I don't think that's going to happen. Thanks, Flashman. All right, here we go. Jury's coming back. And they'll show him just because, juries.
Ladies and gentlemen, I advise that Mayfield will rise to the verdict. Is that correct? Mr. Davis, you received the verdict from the foreman and delivered to the court for inspection from form. Will the defendant hearken to the publication of the verdict? Clerk, will you come forward?
In the Circuit Court, 7th Judicial Circuit, in and for Volusia County, Florida. State of Florida versus Aileen Wuornos, also known as Susan Lynn Vlahovic, also known as Lori Christine Brody, also known as Tammy Marsh Green. Case number 91-257. Count 1, verdict. We, the jury, find the defendant, Aileen Wuornos, guilty of first-degree premeditated murder and first-degree felony murder of Richard Mallory, as charged in count 1 of the indictment. As to count 2, we, the jury, find the defendant, Aileen Wuornos, guilty of the armed robbery of Richard Mallory with a firearm as charged in the indictment. So say we all. Dated at Volusia County, Florida, this 27th day of January, 1992.
Any request from jury for
We would respectfully request that the jury be called.
Will the jury have clerk?
Mrs. Staten, are the verdicts as published your verdicts? Mrs. Farrell, are the verdicts as published your verdicts?
Yes.
Mrs. Mills, are the verdicts as published your verdicts?
Yes.
Mr. DeGanger, are the verdicts as published your verdicts?
They are.
Ms. Mathis, are the verdicts as published your verdicts?
Yes.
Ms. Walters, are the verdicts as published your verdicts?
Yes, ma'am.
Mr. Flowers, are the verdicts as published your verdicts?
Yes, ma'am.
Mrs. Wiley, are the verdicts as published your verdicts?
Yes, ma'am.
Mrs. Boatman, are the verdicts as published your verdicts? Mr. Watley, are the verdicts as published your verdicts?
Yes.
Mr. Aransky, are the verdicts as published your verdicts?
Yes.
And Mr. DeShaw, are the verdicts as published your verdicts?
Yes.
Thank you.
The representative of the city attorney's office, just one, and the defense secretary. Ladies and gentlemen, as you have found the defendant guilty as charged with count 1 of the information of the indictment or the necessary that a hearing be held for the purpose of making a sentence recommendation to the court. I conferred with counsel in your absence, and we will begin that trial at 1:30 p.m. tomorrow, which time I will request that you report to the courtroom and to proceed with that trial. Counsel also tells me, so that you can arrange your time, they do not expect this phase of the case to last over 2 days. At this time, I remind you once again, if anyone who attempts to converse with you or to discuss this case with you, you're notified the work proper will be made with a date indicated. If you're not going to time for this or any recess, you will see where your license may have occurred. You will not read any newspaper accounts or review any radio or television broadcast, telecast after the trial. Do not discuss the case among yourselves with any other person. You will not form or express opinion on this matter for your verdict. For the sentencing recommendation. With those instructions, the jury is in recess until 1:30 p.m. tomorrow, and you will follow the bed.
And there you have it. All the juries, all their names, their last names, and who they go with. That was crazy. I think it was Lori Shaver trial that I heard the judge use the name. I think it was maybe their full name. But they were going down the row and showing Miss Butler. That's insane. Okay. Flashman says the jury deliberated less than 2 hours. Wow. Doesn't give a precise time. Wow. For capital capital punishment. Do you think today, given the same circumstances, they would make this a capital punishment trial, or just a life, make her a lifer? I don't know. I don't know. Been thinking about it, but I have no answers. We will do the penalty phase starting on Wednesday. They do opening statements, and then she looks like she presents like a bunch of doctors, probably to tell us how, well, not a bunch. There's maybe 5. They look like doctors. I'm just looking at their pictures. It doesn't say. Probably we'll learn about how broken she is, and again, I don't know. I would think they would have deliberated longer, but they already had their minds made up when they went back, even though they're not supposed to. It's just a human nature thing. I don't know how you don't. Yes, they definitely did not protect the juries. The only argument to that for me would be is anybody can walk into the courtroom as long as the courtroom's open and see who's on the jury. Doesn't mean they know their names until she read them out. That was crazy. Usually we hear a number. Depending on the state, it's very possible it would be capital. And it was Florida. And they still have it. Yes. Yes. I have not watched any of these doctor. They look like doctors. I haven't watched them. I'm just going to assume, which, you know what that makes. But I want to get I wanted to get that done today. I do have to correct myself on the witness that I told you about, Richard Mallory's girlfriend, the one that was only on and outside the presence of the jury. They didn't put her on the stand in front of the jury. She apparently was interviewed January of 1990. I said 89. Sorry. Somebody would have corrected me. I corrected myself, so we're good. Doesn't matter because she doesn't remember a lot. Because she apparently had a head injury. I don't know why. Head injuries are weird, so it's hard to say what happened with her. I should watch an insanity trial or ones with lots of doctors. This one has 5. That's enough for me. That is enough for me. We're going to finish this thing. We're going to see it through to the end. We will be back Wednesday morning at 11:30. That's 10:30 your time of day. To start the penalty phase, opening statements, see what happens. Gabby, I don't know if that woman's ever going to finish her 1920s haircut. Hair crimped down the side. Doesn't look like it. Hope she's ditched it by now. So that'll be Wednesday. Thursday, we will go do day 2 of the boat club trial in Michigan with Marcella Chittister. That one's rough. It's very rough. And I've thought a lot about Thursday's stream. I probably looked bad, but because I looked like I was laughing, and I know I said it 1,000 times, I was not laughing at the trial. Everybody in chat too it was hard to watch. It was hard to watch. There was a lot of dark humor happening. Nothing against anybody or any victims or anything like that was being said. And nobody was laughing at any of that. But it was hard to watch. If you've not watched it, I would just say, go watch the video of inside the building when she crashed. Just watch that. It's tough. And there's some testimony, the defense attorney. The proof's there that I don't like him. And he did not make me like him any better with some of the actions that I saw. So I'll be very curious to see what your reactions are when you see when you see his, I don't call it cross-examination, because there really wasn't any, of the mother of the two little kids. I wanted to throw my TV. It's a hard trial, Sir Frank. It really, really is. I don't know what else to say about it. It's hard. It's really sad. Makes you very angry. There are some really interesting, though, parts to it that I was not expecting, um, about what was happening in her vehicle at the time. So it's very interesting, but we'll get to it. Gonna get to all of it. So that'll be Thursday. Not sure about Friday yet. If I can stream on Friday, it would be early so I can get it done before Mad Dog gets here, and it would be back more penalty phase with Miss Aileen, which is harder, the boat or the Vander Ark. Well, I despise Shonda Vander Ark. I despise that trial. I despise a lot of things about it. The only thing I like about it is the trial. It's like got me out there, I guess, so to speak. I just it was just my second trial, so not that I'm perfect at it now, but I most certainly have changed the way I do things, my thought processes, and a lot of other stuff that I've just now stuck with, and that thing. So that's why I just don't like Shonda. Nobody should like Shonda. She's not likable, and neither is her son Timothy. And he tricked me, which makes me not like him even more. But that's enough of Shonda. Ugh. And I only have to say her name right because Carmen corrects me all the time if I don't. And I do want to give a shout out to Carmen. She is finally going to days starting tomorrow. No more nights for her for a while. So, what are you talking about, Gabby? But I'm happy for her. And she's happy too. I don't know what you're talking about. The video is playing. I don't know what you're talking about. I just a little bitter. I'm kind of bitter about myself, Flash fan, because I can't. I'm not. I have thought about redoing that one, and I'm not going to. I'm just stuck there. I'm stuck frozen in time, and that's what people watch and still watch it. It's still my top 3. Ugh. So yeah, and I'm not that person anymore. Hey, Zach. Uh, I've watched enough to. I don't know, Gabby. Okay, I was gonna say I didn't see it. I took it down. Nothing's playing over there. I don't know. I've watched enough that I have a lot of dark humor. We've watched a lot of bad people on this channel do a lot of bad things. So there's nothing that's really going to surprise me anymore. Some people suck. They suck bad. And they're where they need to be. I'm kind of hoping that once we get to the end of the boat club trial, that the sentencing will happen as well, and we can just be done. Sorry, spoiler alert, in case you didn't see the video, didn't figure out that she's going to be... There is no question in this one. None. I just didn't spoil anything. Sorry, I did a little, but trust me, there's no question. There's no room. All right. That's all I got. I don't know what's happening with things out there in YouTube land today. Um, I haven't. I can't show it all because I just don't have the time. I'm trying to figure out what to do with it, if anything. I did watch a docuseries. That was interesting. Um, just like everything, people are dug in on their side and there's no bringing them over. So wherever you sit, it's probably where you're going to sit still. Wherever that is. But I don't know. Yes. All right. That's all I got. See you Wednesday morning at 11:30 a.m. Yeah, we need to figure out a way for you guys to watch the rest of it. I just watched the rest of it this weekend. Um, it was good. We'll see. I bet they use it against her. We'll be back Wednesday, Taya, if you can be here at 11:30, and then Thursday evening. Or Marcella. Oh, what is it with Michigan? That was Florida. Anyways, have a good rest of your day. Don't believe everything you hear tomorrow. Remember what day it is tomorrow. I will not be here. I will not play any jokes. And if you're a woman, the one joke I can tell you don't play is that you're going to have a baby, because I've seen people do that. And then guess what? Not me, but I don't do it. Don't do it. Won't end well, or might end the best. I don't know. Depends on if you want kids. But yes. Oh, that's not far from me. Couple hours. Sir Frank, I'll be curious to see what you give a Flash fan. Amusing and crazy out of Vincennes. Not a lot going on down there. Not a lot. Just a little college town. But I'm interested, so I'll watch what you give him. All right, see you guys Wednesday, 11:30 a.m. Eastern Time, 10:30 a.m. Adair Time, 9:30 a.m. Sir Frank Time. He's known as the Panhandle Samurai. Never heard of it. Interesting. Well, wait to see what you dig up. Again, be careful tomorrow with what people are telling you. And I'll see you later.